Very good afternoon, everyone, and welcome to today's uLaw webinar. The topic or title for today's uLaw webinar is Law Office Client Management or Legal Office Client Management. But the exact words that you would use is Law Office Client Management because this is a CPD webinar. It's been accredited for 1 hour of professionalism CPD credits in the provinces of Ontario, New Brunswick, and British Columbia. So you would log into your individual Law Society portals and use the title Law Office Client Management. I'll also introduce you to our webinar link on our website. So if you haven't registered and if you are interested, you're able to register here with your name and email, and you would be notified of all the upcoming webinars. And if not, you can just visit here and look at the specific webinar titles that best interest you. Following this, we also record these webinar sessions so that they're available to you on demand in our YouTube channel. So if you search up ulawpractice, and you would find webinars as a separate channel within, or a playlist within our uLawpractice YouTube channel, and you would be able to consume that on demand as well. Okay. At any time during the presentation, if you have any questions, please feel free to use the chat window to ask those questions. We appreciate if they can be pertaining to the subject matter that we're discussing today. If you have any specific questions about the product, about the company, we'll be more than happy to take that offline and help you understand more through a phone call or an email conversation. Alrighty, so like every other uLaw webinar, today's webinar has this very specific agenda that I'm going to try and cover with the next 55 minutes. We're going to talk primarily about the client intake process, a very fundamental first step in many cases for legal firms to be able to invite their both prospective and customers existing, maybe for a repeat client intake process, or just an intake for a client who's interested in working with your firm for a specific matter. We'll then talk about all the important compliance documents that surround and extend that client intake business process. It's a process. There are many different ways in which you can handle that process, depending on your current situation, whether you're a solo practitioner or if you're a large legal firm or somewhere in between. The process of doing this client intake changes. But regardless of how you approach the client intake business process, there are certain guidelines, best practices, compliance, regulations that allow you to stay right on top of the information that is required for your firm, as well as keep that in a compliant fashion so that you've not missed any specific information that's required to stay in line with the guidelines that the law societies of your individual provinces have provided. Okay? We'll then certainly talk about an interesting topic called group management. It's just a faster, easier way for you, something that you should consider as a best practice for you as a legal firm to manage the various different types of clients that you may encounter as part of your legal business. Okay? When uLaw as a platform and any practice management system that you find these days that allow you and provide you the capability to categorize all of your different contacts, but we're specifically focusing on a contact type that is a client or a ghost client, and understanding the opportunities that you have as a firm, as a practitioner, to better understand your client base by helping group them across various different categories. Okay? A very, very important step of generating a conflict search or generating a conflict search report, which pretty much is a fundamental first step recommended as soon as you've done that client intake process, and going through really the business process of where the workflow of that particular prospective client leads you to within your firm's business process. From a customer, maybe to a ghost client, from a customer to a successful completion of a matter, maybe just a prospective customer who initially does not respond back, but then you're able to convert them into a client. So, or maybe there's a customer that you sign up, but then there for some reason you are needing to non-engage. There could be different steps, different pathways that customer's journey may take them through your legal process, your firm's business process. So we'll talk about that. And of course, last but not the least, we'll certainly highlight the Law Society's requirements when you're after you've done your client intake, some interesting documents that allow you to better validate the client intake process, such as, how did you validate or verify that this is truly the individual or the business that you're dealing with as your client, talking about important documents and making them as clear, precise, and as prudent as needed by the subject matter in terms of your retainer letter or your engagement letter. And certainly we'll talk about some, last but not the least, marketing/compliance documents such as source of contact, and how you as a firm can have a better appreciation not only for the types of customers that is entering your legal business, but the source of these clients as they come in. So you may have multiple areas of practices that you focus on as a practitioner, or you may be a firm that has multiple individuals that work as a team, each of you bringing your own expertise, real estate, criminal, land, lot, and tenant board, small claims. There's a good variety of that. So really having a better appreciation, especially for the small, medium legal firms that have limited time and have to multitask, an appreciation for most of my real estate customers come from Facebook ads. Most of my wills and estate come from word of mouth. That correlation is just going to help you make better sales marketing decisions to help and benefit from those investments that you make to have more leads come in, qualified leads that are desirable to you as a firm. All right. So what is this client intake process? A few weeks earlier, we had conducted a webinar called Everything Practice Management. You can search that up on our YouTube channel. It does fetch you an hour and a half, I believe, of professionalism CPD credits that really highlights 7 key steps that the Law Society, we call it obligation, but really it's a good guideline for you to consider, to keep in mind as you enter and navigate through this legal practitioner journey, right? Now, each province has a slight nuance to these obligations, but we've pretty much covered what all these provinces are talking about and have certainly encompassed it within this presentation. Now, this particular slide share is really almost the first slide or the first obligation that we talk about in greater detail today. And that's about that client intake process, the importance of the client intake and what's to come next, which is the service and communication. It's very important both from a legal standpoint as well as looking out by placing yourself in your client's shoes, the importance of clarity in this whole process, right? There's clarity required from your internal housekeeping or maybe in terms of your own internal aspects of how you run business to have clarity on the client intake process, how easy it is for you to receive information. Likewise, it just makes great business sense that you make that whole process easy for your end customer, your prospective customers, to send that information to you. Having that information tip of your fingers, allowing you to now react faster or responding faster rather than reacting to your customer in terms of the next steps, maybe a retainer letter that's readily available or templatized, adds the professional touch that customers are expecting out of legal firms. That starts the journey of the service and communication. And once you've helped yourself or your firm benefit from that first impression of providing something in a timely manner, really the next pragmatic component of that retainer letter is the clarity around demystifying, if you will, the legal lingos that are sometimes confusing for a consumer or an end customer. So, long story short, it's really making that specific legal matter that you're looking to represent and you need a retainer or an engagement letter signed, making the content of that letter easy to understand, easy to digest, easy to respond back to, and that is part of that package of communication, which the Law Society certainly considers as a professional obligation that you should keep in mind. So it's the timeliness, it's the prudence of the content, and the last thing that pretty much helps you to seal that professional touch as part of that client intake process is the logical closure to a correspondence. So you've had a great start, but sometimes you know how we have a great start but often end not with a great closure, if you will. Sometimes it's left with a little bad taste. So the Law Society ensures through these guidelines that you don't leave your customer with a bad taste, don't put yourself in a legal limbo, and hence talk about the necessary steps to provide a logical closure to a correspondence or a business relationship. For example, if one of the aspects that we spoke about is a ghost client or maybe a client who you've engaged, maybe even created a matter, but haven't been able to proceed any further, maybe did they not respond back to you in time with the retainer, they didn't pay you the retainer. There could be many reasons where you non-engage the customer. There could be many reasons why the customer decides to not engage. So the retainer letter, the engagement letter, needs to clearly articulate the flexibility and the rules and boundaries that you set to enable and take advantage of a logical closure to that relationship. So if you are non-engaging, then make it a point, of course, just like your retainer letter, to have it templatized and available for you to send it out to your customer so that you can clearly state that through this letter, you're relieving yourself or your firm's obligation or responsibility towards dealing or handling with that legal case that was brought to your notice. Right? And in all of this, these are separate business processes. In larger firms, they may be handled by separate individuals or a team of members, but in a solo growing firm, it's just an individual who needs to deal with all of these different business processes, right? And hence, it's very important that you stay vigilant, do the proper R&D to equip yourself with the right tools, the right business processes, understanding these business processes so that you can approach it using the right combination of manual and tool-based approach to help yourself be very clear in how you established your firm to handle these professional obligations, starting with the client intake, service, and communication. So, do you have a website? Where is your client intake form? Is it a web page? Is it a PDF document that you're going to send out? If someone does fill out that form, do you get notified, or do you have to wait for an email to be sent? What if the customer does not send you that email? Then, of course, are you making it a point to remind yourself to call them to ask for the client intake form? And if you get busy, is that lost in translation? Is that a missed opportunity? Right? There's so many different aspects to it. So ensuring that you have the right tools to clearly walk you through each and every business process to stay professional, stay efficient, and compliant. Now I bring up the retainer agreement. But before I go too much into the retainer agreement, I'll try to spend a little bit of time on the intake process. Post-COVID, of course, as you can recognize, a lot of the firms have gone virtual. A lot of the touch points have become virtual. And not saying that that is going to be the case moving forward, but you can certainly be guaranteed of a certain amount of combination of in-person and virtual experiences that end customers are going to get used to, even when dealing with legal firms and legal matters. Right? So that client intake process that used to be in-house, someone walking into your firm to fill out a document, things of that nature are slowly evolving. So people are trying to get away from paper for other good reasons as well. And the most important evolutional change through COVID, and even prior to that, to a certain practice as a consumer, we're starting to make everything mobile friendly. We want everything on our phones. We want everything digital. And we're also seeing a change in the age demographics, if you will, of the customer themselves. So as the next breed, for lack of a better term, of customers enter your prospective client pool of resources or pool of customers, you certainly have to cater to their needs, the Gen X, Gen Y, Gen Z. And we're starting to see a major shift in how this intake process has become that much easier now through helping, whether that's client portal, web pages, a simple automation of a web form, and when someone fills out that form, being to send it as an email so that you're readily responding back in time, has become a pretty standard process across all businesses, not just legal business. And I think through the COVID situation, it's pretty much necessitated the legal firms to closely look at online forms and digital ways to embrace this client intake process. So if you're in that process, great job. If you're considering it, please be aware that that's where the shift is happening. So you're definitely on the right path to convert these paper-based methodologies to digital experiences. Let's say you've done a good job of that client intake process. You have a good workflow of getting the information that you need, responding back to it in time with your customer. Then the next logical next step, before you actually sign the retainer agreement or send them that, is the conflict search. So you've done the client intake process, right? You've sent your customer some information that you need. You've responded back. You do a client search behind the scene, or conflict search rather, behind the scene, to ensure that there are no conflicts in representing this individual firm. Or if there are conflicts, then you need to be aware of it. And if you are still moving forward, then you need to be able to justify as to why you're doing that. And these documents, or the documents that you create to support these business decisions, all become part of that package of compliance documents around the client intake service and communication. And we'll get to it in a minute. But having brought this slide up to talk about the retainer agreement, this is one area. I wouldn't call it a gray area, because then that puts a lot of highlighting or puts the retainer agreement in a bit of a limelight. But it's certainly an area where it can get dicey if the information or the content in this retainer or / engagement document is not clear. It doesn't help you. It doesn't help the customer. And I think the Law Society also wants you to be aware that that is a complaint that in the past has been lurking the Law Society, coming from the customer, saying, let's try and make agreements that much more simpler, easier. And they're also looking to safeguard the interest of the legal firm so that you can be very clear in regards to the expectations that you began in the first place to set with the customer. So that if something were to happen and if this went down south, then you have enough validation And you can always fall back to the retainer agreement because that's one document that you sign between the two parties. That's pretty much a proof of that business relationship that's starting up. So some of the areas for you to consider if you are currently reviewing your retainer letter, or maybe you already have a solid, stellar retainer letter as already, is definitely identifying and clearly articulating the nature and scope of the matter. What are you looking to represent them for? Is this a small claims matter? And then within that, how far does your scope of matter exist? Talking about client responsibilities, and we've mentioned this in many webinars, we've repeated ourselves even in previous versions of the same webinar, having done or handled legal practitioners as our clients here at uLaw, we often find that legal practitioners have themselves a bit of a dicey situation when the client responsibilities are not well articulated. So if you look at some of our templates, we deem to help identify specific paragraphs within a retainer engagement letter that clearly states the client responsibilities. And this talks about not just timeliness of responses, it also talks about timeliness of payment. End of the day, if it is a business agreement, then yes, that's important. Scheduling and course of representation, method and frequency of communication. So this is where within that retainer agreement you can talk about the mode of communication that is preferred. So digital as is preferred today, or if that's your way of approaching the communication or correspondence, then make it very clear that that's how it's going to be. I'm going to be emailing you. My correspondences from my legal firm is going to come through email primarily, but you can always reach us at this number. But of course, stating that if you are going to be charging billable time, then very clearly stating the rules of that game, which really leads to the next aspect, which is the arrangement around that retainer. So how much is the retainer to begin with? When does it need to be topped up if that's your situation? And this varies from matter to matter, right? If this is just an engagement letter where there's no retainer, then of course, as you can clearly articulate from here, there's no retainer involved, but you're certainly talking about how soon would you be generating invoices, how soon are you expecting these invoices to be paid, and what happens if they don't pay you on time, and those important things. Then comes the termination component. So every retainer engagement letter, if you have one today, kindly do reconsider reviewing them again and look at specifically the termination details and the rules around that. Is it easy? Is it hard for both parties to terminate a agreement? How far along do you facilitate that, if any? Is there a hard stop for these terminations? Things of that nature. And of course, the legal practitioner client confidentiality, so ensuring that the information that you store about your customers in any way or method that you use internally to be efficient, that you are ensuring or signing up for that confidentiality, that your information is not shared. And sometimes risks associated with certain methods of communication are recommended to be mentioned in the retainer agreement as well. Here's the risk of email, here's the risk of WhatsApp that I'm going to be using, for example, to correspond with you, or text. Okay, so that was the retainer agreement. If there's a few questions. I think there's a good question around conflict search. I can definitely take this offline, but if you're using other paralegals or lawyers, I think it's really depending on the situation. It's your call in terms of conflict. In some cases, it is certainly a matter of concern, depending on the level of effort that individual has put towards that matter and their involvement in the matter. So really the question is, for conflict search, how do we navigate issues with lawyers who may have to interact with other lawyers or paralegals that we may have used as witness or non-adverse parties in future matters. So the first step in, of course, even understanding the situation, if there is a conflict, is, of course, from a standpoint of capturing that information. Now, as a practice management platform, what we facilitate is the information, and you as the legal practitioner, we hope, are able to digest this information and convert that into meaningful business decisions depending on the situation, right? Because we sometimes do not understand the nuances of the matter itself because we don't read through that. But most often I have heard that if it's an individual who has been involved in another matter, then you need to look at that in a closer scope, understand the nature of their involvement. If there's an individual who's been a witness, depending on the nature of the matter that you're looking to engage them in. Sometimes I've seen people saying, yes, there is a conflict, but I'm still going to move forward with creating this matter because I don't feel that this conflict is going to affect my ability to be prudent towards this file. Okay? I know I've danced around that question, but it really comes down to the nature of the matter itself and the involvement of the individuals in the matter. But the first thing that's important is for you to even appreciate the individuals that are involved when you get a new client. So what are the compliance documents we need for a law society audit? Now, from an audit standpoint, and this is something we talk about here at uLaw, of course, there's a lot of importance given, there's a lot of limelight provided towards the financial accounting and the ledgers and journals and the reconciliation documents and all those fun documents that you have to present during an audit. Of course, there's a lot of importance given to anything trust-related to ensure that there's no misappropriation and misuse of trust funds. Because as the word sounds, it is given to you in trust and in good faith that you would appropriate these funds in the right, legally compliant manner. And that's why auditors are very, very strict about these documents. But the one thing to keep in mind is when you go through an audit, there are some other components of your overall practice management and your overall best practice put to business use that are also taken into consideration. So for example, there's compliance around your client management. There's compliance around matter management. Because we've seen, if you're not using the right tools, in the past, some of our customers who've used third-party systems who've come over or used manual systems mostly may have multiple matters with the same file number. They may not have the right way to do the conflict searches. So there's compliance and there's audit around client management, there's compliance around matter, and then there comes compliance around financial accounting. So from a perspective of compliance around client management, some of the important documents that you may have to keep in mind is the client data verification. This often comes about in a lot of auditors' request, is ensuring that you have the driver's license or the passport of your client, or sometimes the corporation letter of the client, if it's a business matter. And a client intake form that has captured that initial information. So in your case, whether that's web, whether it's a PDF document, an email, however you've gotten that first client intake. In fact, the Law Society does provide you with certain templates to capture some key information. For example, there is at least the first name, last name. Sometimes if they ask you for the AKA name, maybe a correspondence address if it's applicable at that particular time. Little piece of information that go a long way for you as a firm, such as source of contact, that allows you to, again, understand how did this prospective customer learn about your firm, and that invariably becomes an audit report as well, so that the auditors can appreciate that you're not just a referral firm, but you're actually a legal firm that deals with legal clients. Sometimes I've seen auditors ask for a retainer letter just to understand the clarity behind these documents. And another very common document that I've seen is conflict resolution. So we spoke about briefly, if there is a conflict, what happens, right? Some cases you say there is a conflict and hence I'm not taking this matter. In some cases they say, hey, there is a conflict, but I'm referring you to another colleague. Some cases they don't refer you. And the fourth situation is, yes, there's a conflict, but due to such and such reasons, I'm still moving forward with the matter. And that's a resolution documentation, because this is how I help resolve that conflict. At the time of client intake, the auditors may request that you have a date-stamped conflict search document printed, because if that's important really on the timeline in which you did that conflict search. That's why that document is time-stamped. Very critical. Even if you're doing this in a manual way, making sure that the conflict check confirmation report that really sets the stage is time-stamped. Sometimes the auditors may ask to review your ghost client list, if you have any, how you've handled these ghost clients. Has any of them been terminated as a non-engagement, or do you just have a bunch of names grouped under ghost clients and have open matters that don't matter anymore? Pun completely intended, right? And again, in certain times, again, this I haven't seen much, but I've heard that depending on the nature of the matter, sometimes you may be asked to keep a copy of some of the updates that you provide your clients, especially around bill of cost or statement of activity, which is pretty common for legal firms to have for each matter. Yeah. Of course, the closure letter at the end of a successful matter as well, saying, hey, thank you very much for your business. The work's done, and look forward to working with you more, right? Or look forward to your referral for more customers. Or non-engagement is a closure letter which says, sorry, I don't have to work with you anymore, and I'm not responsible for your matter anymore. So a good list of specific documents for you to keep in mind as part of that compliance package of client-related law society documents. And I've always had this slide up because there was one period of time where this was a specific question that was often asked. It was slightly off tangent from who we as a company do. So the non-engagement letter is really how you remove yourself as their legal representative. And yes, there is a template. I know I'm shifting gears here, but hopefully you can accommodate that quick change. So if you are in a matter, right, and let me look at a specific example here. So you can load a non-engagement letter. This is one of the samples, so I'm just going to quickly draw up one of the non-engagement letter samples. And this is interesting because it pretty much mimics a non-engagement letter sample from the Law Society, but we just help pre-populate the information for you. It has your information as the legal representation, your client's information with their mailing address. If there's a court number, you can put that in. If not, leave that empty. So it clearly states that, hey, this letter is further to our initial meeting. Unless we received whatever, if that's the case, we've not received any funds. So this is very specific to non-engagement where you've not received funds and you would set the expectation that you would. So this line is the bottom line. We confirm that we do not have any documents belonging to you. All documents were returned at the end of the meeting. And That's pretty much it. This is one sample. Okay. So how often do I reach my client? Because this is, again, a thin line. Once again, I hate to say it, but it's dependent on the nature and scope of the work, especially if this is a non-retainer letter situation. If this is where you have to, you're working on a operating account, you don't have trust funds to deal with, the most obvious series of documents that you may send your customer are the invoices. So after you've done your client intake, once you've started the matter, as part of that overall ongoing service and communication, one of the more, pragmatic or very practical application of documents would be the invoice. You may have, again, that goes back to your agreement. If you have signed up an agreement and the customer has signed up that agreement saying that they're okay with you invoicing them every time that you dock it or every time you disperse, then the possibility of multiple invoices within a short time is highly probable. In the case of corporate matters, we've seen legal representatives providing a monthly statement of activity that is attached to an invoice. So again, it comes down to the retainer letter. It comes down to what you've signed up for. So WYSIWYG, what you've signed up is what you get. But in a good rule of thumb or some guidelines is stick to your retainer engagement letter obligations. Make it as crisp and clear with all the documents. Make it easier, and this is something I'm adding today in today's context, make it easier for your customer to consume that document. So it's okay to send print as long as you can facilitate some digital touch points as well. Make it secure, of course. Quarterly updates. So there are some matters, corporate or criminal sometimes, some large estate matters, which may be ongoing, that require, quarterly updates or maybe monthly update of information of work being done by the legal firm. So that's important to keep in mind. And if this is a matter that goes beyond a year, again, nature of matter, then yearly updates become an important component of the overall correspondence service communication. Some interesting questions that we've got on our chat. So, of course, one question is around sending back so basically refunding your retainer. So yes, e-transfer is it's not a frowned upon way of refunding the retainer as long as you have the right bookkeeping done and you've ensured that all that information is clearly saved. You have an audit trail of all that information, right? So yes, by all means, you can send an e-transfer back to your customer, get that acknowledged, and make it available. But of course, each financial transaction that you utilize has a certain cost. Oh yeah, thank you very much. Yeah, there is a cost associated with these transfers that you should be, again, it's a little fee that you pay for the convenience, I guess, that you get. In terms of us able to remind you of the situation, that's a good point. We today give you the information but I will certainly take that feedback to see if we can help remind you, because we have a huge series of reminder systems that are built into the system already, so we can certainly plug in these reminders as they are necessary. Okay. Okay, so we have another 15 minutes or so left in the presentation. So in terms of managing groups of contacts, and we talk about contacts, but I certainly want to stick to the component of clients, because this is about client correspondence. But I'll leave you with this, that as a legal firm, it's best to first find ways of categorizing your contacts, clients being one of them. So you may have vendors, you may have other legal representatives. So that's very important that you store all that information so that it's easier to do conflict searches now. But to categorize them makes it easier for you to understand the variety. But most often, you're not looking for a variety of where did this representative of the opponent get to know me. They just ended up being because of the situation that they were in, right? But where you're really interested is the nature and scope of the client, the categories of clients that you're dealing with, the sources of contact from which they've come from, and hence, though uLaw does and other practice management platforms do allow you to categorize contacts, we put extra emphasis on you finding a process to categorize clients. So for example, you can categorize clients by area. You can categorize clients by scope of or nature of matter. Those could be small claims, LATB. So you may have a little group of all, here's 22 LATB customers that I've dealt with. Easier for you to deal with. You may categorize sometimes clients based on the type or the nature or the role that they play in a type of matter. So, for example, a landlord, or maybe a plaintiff, maybe in a family matter, you have an applicant-respondent situation. So that's another type of categorization of a client. And of course, the more natural fourth one would be the ghost client, which we already have, but that allows you to now segregate clients and ghost clients, and then further segregate within the clients the type of categories that you have. We have even customers who have categorization under ghost clients, interestingly enough. So you may have ghost clients area 1, ghost client area 2, and you can add as many groups as you like. You don't pay for these things, so might as well make them as granular as you need it to be. Source of contact, that's another important classification. That's you understanding where did this customer get to know you to begin with. Yeah, sometimes, so the question is there a way to categorize agency representation? So many times that happens in the matter itself. So your end client is a agency or a lawyer that you work with. So many times it's the customer, the lawyer themselves is your customer, and you may have multiple matters under a customer, or you may just have each and every end client as a customer, but then you're billing it to this one lawyer. So there's many different ways that you can approach that. All right, we talk about conflict checks. I think we just have a few more slides to go, and then we'll be good. Okay, so from a conflict check perspective, some important details to keep in mind. So you've done the client intake, and then you're, of course, naturally doing this conflict search. What are we looking for in this conflict search is we're looking for specific details, first based on the name that you've gotten through this client intake. If that is a common name, then you want to go one step granular to understand if you've dealt with this client in a different manner. So one way of knowing that is if you associated this client as a party. So if they were a witness, have you associated them as a party? We even allow you to enter this in a docket. So if I met with Peter, the neighbor, or something like that. So the next time there's a Peter Piper that shows up, we're able to catch that little note that you put in the matter description to say there is a little instance of a name Peter in this specific matter. And then you can go into the matter and then look it up further, right? For example. Now when you do complete the conflict search, there's some additional details that you really want to help yourself with. That is, who actually took that client intake call, right? Or did that come through online? Do you have some specific details, such as the correspondence address, any way of communicating, email, phone? Who actually performed the search? So if the conflict search was done, who did that? So is it a front office personnel, or was it just yourself, in which case it would be your name? This particular screening form as a template is an audit document, or is a document that helps your case during an audit. It's not really the conflict search report, it's the, how do you call it? It's a screening form. That's the title. So you have a conflict search and you have a screening form that's supportive of it. So two documents towards the conflict search. One is the act of searching and retrieving the information, having proof that there is or not conflict. This document is your validation, saying, having reviewed this result of search, I'm complying to this conflict using this form. By not telling the auditor or telling the law society, this is what I did, having got that conflict search. Okay, so two documents really, if you really want to be very specific about the compliance nature of it. And kind of last but not the least, from a client management perspective, and this may not necessarily be important from an audit perspective, but it certainly is important from your firm's understanding of your client's perspective. So you've now understood the client intake process, the source of contact. You've also maybe understood the group or the category in which these clients exist. You've even maybe understood the nature and scope of the matter. So now you can start drawing inferences from all of this. So you can run reports and then draw outcomes out of these reports. So for a good example, you could eventually through these reports talk about, I get maximum profit from these types of customers who eventually, or I've found out, come from these sources to begin with. So good quality clients who give me profitable business from let's say, a specific source. And then, or maybe there's a specific type of client. So maybe I'm doing really well with plaintiffs. Maybe I'm doing exceedingly well with tenants. Maybe I'm doing very well with criminal matters. And if that's the case, then you need faster, easier way to also understand the economics behind these clients, right? And again, this gets granular, and there's a webinar very specific to the analytics that we cover. This talks about now getting into the nuts and bolts of it, talking about the revenue, the expense, the days of sale. So maybe there's certain types of matters that you really don't want to deal with, but maybe you're getting a lot of clients in that scope. So the analytic engine that we have, and the analytical engine that you should think about, whether that's manually done through an Excel sheet, or it's in your mind, or it's in a practice management accounting software like uLaw, you really need to keep in mind that these analytics are indicative points that talk about a bigger story. And if you can find the dots, you can certainly understand a bigger picture here. And we recommend looking at these analytics sometimes weekly, sometimes at least twice a month, so that you first can validate if you're going down the right path. And if you are, how can you help yourself be better and faster and efficient with it? But most importantly, if you're not going down the right path, you can take corrective measure and redirect yourself towards a more profitable, successful business management. So client analytics, understanding the aging report, which says these are the top clients that haven't paid me in time. Typically have taken me more than the initial days of sale. So my net 30 with these customers have eventually become net 45 or net 60, and then translating back to what was that type of customer, and then translating back to where did these customers come from. So maybe your word of mouth is not great because the quality of that customer is not great, or maybe your quality of that customer is phenomenal because it's a word of mouth. So there could be many different inferences based on the data and the analytics that you can drive out of all the data that you're storing in any system of use that you have. So all we're saying is please take advantage of the data. Either use a tool or a platform or a product to help crunch that data into information, or find ways to do it yourself so that you can take corrective measures or better ways of handling prospective clients. Okay. Of course, last but not the least, we continue to talk not about uLaw, but in general talk about the need for legal practitioners in Canada considering a legal accounting and practice management software, and best if you can have a single platform that does both. But legal accounting becomes important because that's where all the information between two different silos of client, matter, converge in terms of your final business outcomes of funds, revenue, expenses, and that information then being related back into compliance documents like ledgers and journals, because money management is a big aspect of legal business, especially if you're dealing with trust funds, because you're then dealing with your client's money primarily. So when you are exploring a system or system of record for moving away from other systems, please do consider the top 4 benefits of a legal accounting practice management system, which is, of course, the total cost of ownership. How much of time and effort does this reduce you? How much of labor does that reduce that you're now currently paying to help manage all of these business processes? The efficiencies that you're able to derive out of the time that you've now saved. Some of these tasks can be automated. The importance of compliance, which cannot be not seen. In Canada, of course, you are getting audited within the first 8 to 12 months, or maybe first 14 months of your business, and then there's a cycle for those audits. And last but not the least, this has become table stake today, right? The need for the flexibility, whether you're using it or not, the flexibility and the conceived notion of freedom and being able to practice your business, have access to information from anywhere, right? Again, depending on the nature of the business, we find some of the practitioners cannot be necessarily in the country, maybe outside the country to do still business here. But in some silos, that may not be the most probable situation. Regardless, even if you're not even within the same city, you don't have to necessarily go to the office. Maybe you have a virtual office. You don't have to spend on real estate or a brick and mortar office anymore. You can be working from home. So practice anywhere has become this big mantra across all businesses. And the legal business is slowly acclimatizing to that situation. Alrighty, so that's everything that I had for this presentation, truly, to reiterate the webinar. The title, once again, was Law Office Client Management, and we specifically went over the client intake process, the service and communication, if you remember, the importance of that, the Law Society's requirements around important documents that you need to consider producing when being asked for, including things such as the client ID verification, samples of your retainer letters, and things of that nature. We spoke about how best you can handle conflict searches, the two documents, the search report, as well as the screening form that combine to provide a very holistic compliance approach. Bringing a logical closure to your correspondences through non-engagement letters or otherwise, or maybe a closure letter at the end of a matter. We spoke about that. And last but not the least, we certainly spoke about the importance of a legal accounting practice management and necessary need for consuming data and making good business decisions out of that. Okay? So with that, I'll turn the chat window for any specific questions that you may have with regards to today's webinar. And definitely thank you for your time. Okay, in terms of the screening form, I think there's a question about the screening form itself. So, conflict screening. So under a matter, under a compliance, in uLaw, you have a compliance panel. And if I go under conflict screening, here's a document which says, all right, who is the person taking the call? You can we start you off with certain basic information that we already know, and you can add to that after that, right? So this document, of course, is dated for today. This is where you say, all right, this is a new client or a new matter for an existing client. That's very important. So let's say this is a new client. Conflict search information. So in this case, we did have some conflict around, we've got the different parties involved, right? So if you look at the matter itself, in my parties, I have a tenant, I have a representative of the opponent, and that's what I have here. Again, these are just fancy names that I provided. And who is this done by? This conflict done by, right? Now, if there is no conflict, you can do that. You can say conflict confirmed. You can say that. Possible conflicts. And this is where you can talk about the details on the confirmed possible conflicts and any steps taken. This is the standard text that the Law Society provides you. Potential relevant people have entered entries. So this is an example of the conflict screening form. The conflict search happens at the contact level, where you're actually doing a conflict check. Let's call it a check for now. But this is a document. It's not a Law Society document, but it's really a very supportive document to this, right? So for example, if I were to search up, let me go into the dashboard, get Bob General. And if I were to do a conflict check, I'm just going to do a first name, last name. So here's a conflict check report. There's a Mickey Mouse. There's a Mickey Rooster for Kangaroo Mickey. So this is a conflict search document, and you can say it's date stamped. So if this was done at the exact time of that client intake, this document, along with this, pretty much combine to provide that conflict search. Okay? Okay, it is the top of the hour. This session is being recorded and will be available to you as early as Monday next week. And I look forward to seeing you in our next webinar. Please do tune in to our info.ulawpractice.com/webinar, and do subscribe to our YouTube channel if you'd like to learn more about our CPD sessions. And this is 1 hour of professionalism CPD credits is what you've gotten today. The title is Law Office Client Management. 1 hour of professionalism credits. Okay? Thank you, everyone, and hope you have a great weekend ahead.